Resuming debate, the honourable member for Windsor West.
Thank you, Madam Speaker, and I'm happy to start this week to speak to Bill C-27. Quite an extensive bill, over 140 pages in length. It actually amends several acts, and the most consequential are three of them in particular. So it's an act to amend the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence Data Act, and make consequential and related amendments to other acts. Now, Madam Speaker, I should start by saying that this is really three pieces of legislation that have been bundled into one. As New Democrats, we have actually called for different voting for the third and final part of this act. The first two parts of the act being the Consumer Privacy Protection Act and then the Personal Information and Data Protection Tribunal Act do have enough common themes running through them to be put together in one piece of legislation. I still think it would be better in two separate pieces of legislation for those issues because one of them is brand new. The former first one is the act to the Consumer Privacy Protection Act is a former C-11, which was highly controversial in the previous parliament. And when we had an unnecessary election called by the Prime Minister, that bill died with all of the work for Parliament that was not concluded, despite extensive lobbying and consultation, going particularly through the Ethics Committee at that time in particular. Now this has been bundled with some other legislation to go through the Industry Committee, which is fine. The Personal Information and Data Protection Tribunal Act is a new component of this legislation. I have some concerns about that element of it, but it does have a common theme that is worthwhile, and at least it has a potential to be put together and bundled, although again extensive. It's one that we can accept. What we have called is for a speaker's ruling with regards to the Artificial Intelligence and Data Act, as this is brand new legislation as well, but doesn't have the same connections as the previous two pieces that are bundled together in a way that one could argue for them. But the second part of this, we want a separate vote on that because the legislation will be studied at committee together. There will be a high degree of interest in this legislation since, again, C-11 did have that in the past. The new bill right now is actually going to change from the position from C-11 significantly. So I expect that itself will garner a lot of different types of chatter and also review and interest amongst a number of organizations, many of whom we've already heard from right now. And the other part with the tribunal will be another important aspect because it's a divergence away from our traditional way of enforcement and creates another bureaucratic arm that again, I'd like to see more on this, and I'm open to considering the idea, but it certainly is different than our private right of law that we've had traditionally to have dispute settlements with regards to data breaches and other types of corporate malfeasance and others that have actually had to deal with the types of laws that are necessary to bring compliance upon people. And this goes to the heart of really where a political party resides with regards to their expectations of companies and the use of data and information and algorithms. And for New Democrats, we fall very much in line to what I have tabled before several years ago as a digital Bill of Rights, so that your personal rights online are consistent with that of your physical rights, where you are expected to be properly treated in a physical world, and also a way that it should be also exemplified on the digital format world. And that includes your rights to privacy, your rights to expectation of proper behavior conducted to yourself, and the rights not to be abused. And there should be significant penalties to those that actually do those abuses, especially when we're looking at the corporate world. And then where this legislation really becomes highly complicated is the artificial intelligence emergence that's taken place over the last decade, but will be significantly ramped up coming forward in the years to come. And that's why the European Union and others have advanced on this, the United States, Our concern is this bill tries to split both worlds, and we all know, quite frankly, the industries of Google and others, web giants, have had significant lobbying efforts over the last number of years. In fact, they've tripled their efforts since this administration has come into place, and have had quite a direct line of correspondence going with regards to that lobbying, which is fine to some degree, but with the expectation that it would be balanced amongst people, it doesn't seem that it's taking place with this. So I want to bring into the discussion here to be a little more practical before I get into the technical aspects of the bill with the impact on people and the data breaches that we need to remind ourselves. That's why we need to have protection amongst our citizens and amongst other companies as well, too, Madam Speaker. One of the things that's often forgotten is that other small SMEs and others can be compromised quite significantly from this. And so protecting people individually is just as important for our economy, especially when we have the emergence of new industries. And if their behaviors are hampered or are basically manipulated or streamed, they can become significant issues. But if I want to remind people, though, that some of the data breaches we've had is Yahoo, Marriott, the Desjardins Group, and Facebook, among others, have seen significant differences between the regulatory system between Canada and the United States and how they treat the victims in the country. A good example is in 2009, a settlement in the U.S. with regards to Equifax data breach. In the case that brings it to a specific is that Equifax agreed to pay $700 million to settle lawsuits over the breach and agreement with the U.S. authorities and states that includes up $425 million in monetary relief to consumers. And we have not had the same type of treatment back here in Canada. This is similar to, Madam Speaker, the work I've done in the past with regards to the auto industry and the fact that our Competition Bureau and our types of reimbursement systems are not up to date. And we have been treated basically as a colony amongst many of the actually industries when it comes to consumer and retail accountability. You could just look at the example of Toyota, for example. This is a data software issue. If you remember, it was the pedal that was blamed for the actual car going out of control. And it turned out that's not the case. It was actually data. The U.S. resulted in hundreds of millions of dollars of investment into safety procedures. Because of that, we got zero for that. There was also consumers got a better treatment where their vehicles were towed back to dealerships to be fixed. And where in Canada, we didn't receive any of that. Same could be said with Volkswagen, another situation that took place with regards to emissions, where not only did we not receive compensation similar to that of the United States, we actually imported a lot of Volkswagen vehicles that were used from Europe, but that was on our own accord and time frame when those vehicles were being basically sunsetted in those countries because of emissions. In the case of Facebook, the U.S. Federal Trade Commission was able to impose a $5 billion fine for the company's violation, while the Privacy Commissioner Office was forced to take the company in federal court here in Canada. And that's one of the things I'd like to point out is our Privacy Commissioner and our office has well stood the needs for Canadians. And one of the concerns with this bill will be the erosion of the Privacy Commissioner's capabilities with regards to dealing with these bills and legislation. The Privacy Commissioner has made some significant points with regards to how to amend the bill and how to actually balance the bill. They have not all been taken into account. So that'll be one of the strong points we'll be looking forward to see if there's amendments that are necessary from our Privacy Commissioner in this. So one of the big distinction between Canada and the United States in our benefit and to Canada's credit is the Office of the Privacy Commissioner, whereas we don't have some of the teeth that's necessary for dealing with these companies. We do have the independent Privacy Commissioner that's able to investigate and to be able to follow through, at least with bringing things to, I guess, a formal process through the legal system. It's very laborious, it's very difficult, but at the same time, it is independent and is one of the strengths of the system that we have here as well. And so when we look at the bill, and if the government proceeds, it's going to see this go to committee, which we're agreeing to do. And we do want to see the separate voting. And so I'll before I get into the more of the thing, the bill, is we want to see the separate voting again, because we really distinguish the fact that this is inappropriate in terms of the Artificial Intelligence Act being the first time that we've actually even dealt with this in the House of Commons, and it really should be something done differently. So we will be looking for amendments for this, and we've had big corporate data privacy breaches becoming quite the issue. In fact, even some of these privacy breaches get highly complicated when it comes to dealing with them. There's been cases with cybersecurity, even extortion taking place. The University of Calgary was one that was well noted. There's been others. And so we need to have some of these things brought together. And it's important because the bill does include some important fixes that we've been calling for stronger enforcement of privacy rights, tough new fines, transparency, and corporate decisions made by algorithms. And so, I do want to, I've pointed out a lot of the concerns that we have about the bill going forward is just because of the seriousness nature, but we are glad that this is happening, albeit again, with the caveat that we feel it should be separate legislation. But the minister does deserve credit for bringing forth at least bill or trying to bring this debate to the House of Commons. Again, C-11 should have been passed in the last parliament, but here we are again dealing with it. And the new tribunal is the concern that we have, is because it could actually weaken existing content rules. And we'll study to look at this new tribunal. The tribunal itself is going to be interesting because it's going to be an appointment process. There's always a concern when you have a government appointment process. There's a concern, too, that there could be complications setting up the tribunal, who gets there, on what their background is and what their profession is, and whether or not there's going to be enough support. One of the things I've seen that gives me trouble is that CRTC, for example, the CRTC takes so long to make a decision. It's so laborious to go through, and it has not always acted, most recently, in the best interest of Canadians when it comes to consumer protection and individual rights. That it gives me concern that another tribunal to act as a referee instead of the court system could actually delay things. And there's some testimony that's been provided already in terms of analysis that suggests that this tribunal thing might also end up with lawsuits anyways. So we could be back to square one potentially after that. And so the time duration, the funding of it, the ability to investigate, and all those different things are very good, and very good issues to look at and to find out whether or not we're going to have the proper types of supports for such a new measure brought in. Another government resource for this is key, because if it is very much at the end of the day a tribunal system that is not supportive of protecting Canadians' privacy and rights, then we will weaken the entire legislation. So that's a big concern, because that would be outside of Parliament, and the way that some of the amendments and that are written in here could be coming through more regulatory means and less of parliamentary oversight. So who's on the tribunal again, how it's consistent, how it's going to basically regulated. And again, I would point to the CRTC, where the minister provides the CRTC with a mandate letter, so to speak, where they're supposed to actually emphasize the public policy direction they should go. And in my quite frank assessment, the CRTC has not done the consumer protection that New Democrats would like to see over the last number of years. Now, when it comes to modernizing this law, we do know that this will be important to address, because there's issues with regards to the data ownership that's really at the heart of some of the challenges that we face. There's everything from algorithmic abuse, but there's also areas related to compensation, enforcement, data ownership and control, and a number of different things that are necessary to ensure the protection of people. When you look, for example, an area where I've done a fair amount of work and where my area comes from is the car, with automobile production, there has been basically the production of the car, and the value there, but also too, it's going to be the data collection and the use of that data collection that can actually influence not only your individual behavior, but that of all of society. And that's a significant economic resource for some of these companies. It's one of the reasons I've tabled an update to my bill on the right to repair. The right to repair is your ability to have your vehicle fixed at an auto shop of your choice in the aftermarket. The OEMs, the original manufacturers, have at times resisted this. There's been examples, say, for example, Tesla is not even part of what's called the voluntary agreement, but we still don't have an update with regards to the use of data and how that actually goes about the process of fixing your vehicle. It also creates issues related to ownership of the vehicle and also insurance and liability. So these could become highly complicated issues related just to the use of data and the rules around it. And so if we don't have these types of things clear with regards to the process of rights for people, expectations by those that are using the data and protection for people, then it actually can create a real significant issue, not only for individuals, but our economy. So dealing with this issue in the bill is paramount. And a lot of this actually comes about by, looking what the GDPR did, and this is the General Data Protection Regulation, European law. They were one of the first ones to actually bring forth this type of an issue and have actually provided an adequate level of protection, is one of the things that they stand by with regards to protection privacy. There's been some on the side over here in North America that have pushed back against what the GDPR is. And even though this landmark legislation has created a path forward, there still is really understanding, what is going to be, the penalties for monetary abuse and transparency, which is also very much important to what we expect for this legislation. So erosions of consent rights is one of the things that we're worried about in this bill. Individuals on C-27 would have significantly diminished control over the collection, use, disclosure of their personal data, even less than in C-11. The new consent provisions ask the public to install an exemplary amount of trust to businesses to keep them accountable, as the bill's exceptions to consent allows organizations to conduct many types of activities without even knowledge of the individuals. The flexibility under C-27 allows organizations to shape the scope of not only legitimate interests, but what is reasonable, necessary, and socially beneficial, thus modeling their practices in a way that maximizes the value derived from the personal information. So what you have there is that the actors are setting some of the rules. And that's one of the clearer things that we need through the actual discussion at committee that will take place, but also from the testimony that we'll hear, is because if we are actually letting those that use and manage the data have the, thank you, Madam Speaker, have the decision about what is actually consent and how it's used, then it's going to create a system that really could lead to abuse. And there's also the issues of a danger of de-identification. With this is artificial intelligence and you being able to actually scrub much of your data when you want, how you want. That is one of the things that we're concerned about. There is not enough acknowledgement of the risk that's available in this, and that includes for young people. We believe that this bill is a little bit lopsided to the business sector at the moment, and we want to propose amendments that will actually lead to better protection of individual rights and having informed consent as to what you want to do with your data, how you want it to be exercised as a benefit to you and your family versus that of you being accidentally or willfully brought into exposure that you have not consent to. So as I wrap up, Madam Speaker, I just want to say that we have a number of different issues with this bill. Again, we believe that there should be a separate vote for the second part of this bill, being the third piece of it. It's very ambitious legislation. It's as large as the budget bill, and that should say enough with regards to the type of content we have. And I thank the members and who have debated this bill already. It's going to be interesting to get all perspectives, and I look forward to the work that comes at committee, but it will be one that requires extensive consultation amongst Canadians. Thank you, Madam Speaker.
Questions et commentaires, questions and comments. The honourable member for Dauphin, Swan River, Nipawin.
Thank you, Madam Speaker, and I thank my colleague for the great intervention there. I was just wondering, he touched a little bit on children's and personal rights protection, but I wondered about if he could comment on seniors and what kind of impact it would have on them if they've got exposed to this legislation, and how could this legislation, in fact, harm seniors more, especially if they made it more bureaucratic.
The honourable member for Windsor West.
Thank you, Madam Speaker. And I really appreciate that question, because I did not touch on seniors, which I really appreciate the member raising, because, we don't even have consistency right now in your decision-making process about privacy, as you currently now agree to a number of different things by clicking the box, and there's no standardization of it. And with seniors, we've seen, even, let's say, for example, the Arrive Canada app, the confusion that can take place as we have complex technology at times thrust at them during times of stress and times of highly important decisions. And as we move towards this, I think the member brings a good point in the sense that we have those seniors and also other people that will need some type of support, education, and coaching that goes along with this. And being very much, shown in a plain language, in the sense that, we're dealing with a highly technical bill here that we've had to scrub through the system several times to go through it. It's unbelievable in terms of the complications it has. And we know that we have a very good educated population, but this is a big change. And I hope that there'll be a program of education as part of this. And that's a good point. The seniors actually have been left out of this debate, and I'm glad the members raised that.
Questions and comments, questions et commentaires. L'honorable député de Châteauguay.
The honourable member for Châteauguay-Lacolle.
Madam Speaker, and I really appreciate the speech by the honourable member from Windsor West, especially around this issue of artificial intelligence. And I'm just wondering, this is a brand new area. How does he feel about the fact that this is important to? Does he think that we are ready to legislate in this area? I know it's an area of concern for my constituents, and I'd like to hear his thoughts on that.
The honourable member for Windsor West.
Thank you, Madam Speaker, and I appreciate that question as well. And I think we are, and I do, applaud the minister for bringing forth the issue to Parliament. Again, I think that, though, I just want to exercise some caution about the first two pieces of the legislation are much easier to deal with, because at least there was some discussion with C-11. It's a little bit different in this one here, and the tribunal's an issue, but I'm open to looking at it. I just have concerns about that. But the artificial intelligence part of it is critical, and I'm glad it's in front of us, but I think it's going to require much more extensive debate and care. And that's why I think it actually should be entirely separate. Now, what we've proposed as a compromise as the NDP, I think is a fairly reasonable one, the Speaker will rule on, is that there be a separate vote for that particular part of the bill. And the reason for that is that because perhaps the first two parts could lead to, maybe a decision that might be different on the last part, just to ensure that we're going to get enough testimony and time in committee for it. And so I'm looking forward to all perspectives in the House on this. And I think it is time for us to look at that. And I think it's a reasonable position. And I'm glad it's in front of us. I just don't like the way it's in front of us. But we'll deal with that.
The honourable member for Berthier-Masquinongé. Thank you, Madam Speaker. And I'd like to thank my colleague for his speech. This is a critical time. This is a delicate and very complex subject. These are areas that were not previously regulated. It's important to get it right. We need to take the time we need to do just that. There are things that are needed, for example, adapting with provincial and Quebec legislation. We know that there should be no overlap if there's any equivalency that's already there. I'd like to hear from my colleague. Will he commit? Because I think his party has a bit of trouble respecting overlapping jurisdictions or jurisdictional issues. So that's the first part of my question. Will my colleague undertake to respect what's already out there in Quebec and the provinces? The other thing is that this party has a tendency to limit debate, and I'm concerned about a bill like this being subject to that kind of limited debate. Will the member commit to respect Quebec's jurisdiction and a full debate? The honourable member for Windsor West.
Thank you. I thank my colleague for the questions, and I have extensive notes here, more than I could even go through with regards to this bill being the pages that it is. And first of all, I think my party has an exemplary record of actually respecting Quebec and using, including this bill, some of the practices in Quebec that are actually solid for all of Canada. So I disagree with him on that. And I also, at times, I have seen his party also close debate many times during the years that I've been here. I've been here just over 20 years, Madam Speaker, and the Bloc has limited debate on different bills at different times for different circumstances and so forth. And so I want to have a robust discussion about this, and we're committed to that. I've expressed that to the minister and to other parties, including anyone who wants to talk about this bill to try to make sure it gets its due course. So those are the things that I think that are quite strong. And I'll complete just by again saying, Madam Speaker, I think what we've shown is some of the best practices from Quebec are part of actually our strategy. And so that's flattery. It's not at odds with Quebec.
Questions and comments? The honourable member for London Fanshawe.
Thank you, Madam Speaker. And I appreciate the complexity with which this bill has been introduced and presents to my honourable colleague and the work involved in going through it. He mentioned about the problems in terms of the tribunal process. I know that the Privacy Commissioner has raised a lot of concerns. Could he perhaps go into a little bit more detail about the insistence that our party certainly has, but the Privacy Commissioner has raised in terms of ensuring that the consumers have far more access to that fairness within this legislation than typically organizations would have, because they have more monetary resources to pursue things under legal precedents. Thank you, Madam Speaker.
The honourable member for Windsor West.
Thank you, Madam Speaker. I thank my colleague from London Fanshawe for that question, because it is something I didn't touch on. Again, there's so much in this bill. And so she's quite right with regards to that if you actually, as a person, want to actually take a legal right of action against an abuse, it's going to be quite more cumbersome for yourself. And if you're a company, you would have a better chance for that. The tribunal and the division of power with that of the Privacy Commissioner is going to be very interesting. I guess what I don't want to do is anything that would undermine the Privacy Commissioner. I suppose I'm biased in the sense that, I mean, from my experience, the Privacy Commission has been an excellent model, has done some excellent work, and needs more support. And that's the other thing we have to do, is that we're going to give them more responsibilities, they'll need more support. My worrisome part is that the tribunal will be a little bit disenfranchised from that consistency. And that's one of the reasons we want to see this debated thoroughly.
Time for one more question. Nous avons le temps pour une autre question. Questions et commentaires? Questions et commentaires? L'honorable député.
The honourable member for Mirabel. Thank you, Madam Speaker. Look, we know that data can be very useful to companies in providing consumers better products and services, but it can also be used in a major way to reduce competition, to charge a higher price to one person instead of another for the same product, or to increase the prices for delivering food to areas where there's less competition. So it can be used in ways that run counter to competition. So Canada has a system that's very outdated, and I wonder whether, in his view, the member thinks this bill will bring back some justice toward Quebec and Canadian consumers who are currently very likely to get had by companies that have access to their personal data unbeknownst to them. The honourable member for Windsor West.
In a minute to respond.
Thank you, Madam Speaker. That's a really interesting and good question, actually. It is going to be really where we want to steer as New Democrats this towards, is more empowerment to consumers and watching that abuse be eroded. The problem that we have is that some of the companies and lack of competition that we have in Canada right now could even lead to greater abuse potentially, because the information, the sharing of data could be done behind closed doors and behind the system of accountability. So that'll be one of the things to watch for, and that really is our objective of parliamentarians. So I'm glad the members raised that, because I think it's one of the ones that we don't want to lose sight of. A good example is that we see outright abuse of competition right now. When we had the Loblaws bread scandal, they also were putting their money offshore, and then on top of that, they ended all their pandemic hero pay at the same time. So these are good questions.